Hello, hello. How is everyone doing tonight? We've got some interesting developments in my Florida Circuit 7 case, and we want to share that with you.
Yeah, if you want to wait a little bit, give people a couple minutes to join, since you told them be on at 8 o'clock. Oh, yeah, we're past
8:15. Sorry, guys. All right.
It's been a long day. I lost track of time.
It's been a long year. So we are on DIN 221, and that was my motion to stay enforcement of driver's license suspension. And that's the interesting development that happened today, is I finally got a response on that motion.
Well, now this was, so this is separate from the actual hearing that Heather had last week or 2 weeks ago for her objecting to them potentially suspending her driver's license. So she had filed two things. One, she had objected to them potentially filing it, which was a procedural thing you have to do when the Department of Revenue sends you that letter. But then she also filed a separate motion to stay, meaning having the court block the Department of Revenue from actually suspending her license. And of course, the objection to suspending her license triggered the hearing last week. Heather filed a motion to vacate it, and that has triggered a new hearing on Monday via Zoom. Yeah. But we got a response to this today.
It definitely, as a strategic move, it almost, to me at this point, feels like they are trying to get me to focus on the driver's license issue, so it trips me up on my initial brief that's due in District 5 Appellant Court on July 17th. And if that's what they're trying to go with, no. I've already got pretty much my entire brief done, so it's just fine-tuning it and
getting it formatted.
Yeah, and getting all the formatting and the appendix and everything done. So if this is them trying to be strategic with trying to screw up my appeals case, it's not going to happen. But what it is triggering now is me to file violations of my constitutional rights into my docket. So I filed this motion to stay enforcement of driver's license suspension back on June 23rd. That triggered the hearing on the 17th, where it was 15 minutes, and the attorney, Alan Holt, for the Department of Revenue, objected the moment I started speaking. You can see that in the video that I posted at the hearing. And every time I tried to continue speaking, because I had a whole bunch of documents laid out on the table, they just kept talking over me. So I finally had enough, and I'm like, all right, I guess I'm talking over you. And then, of course, they accused me of talking over them. And I made it very clear from the moment we sat down that I had a lot of documents as exhibits to present to the court, and that I wanted to take my full 15 minutes, and they absolutely refused, and that is a due process violation.
Not only that, when Heather finally did get the bailiff to hand the attorney for the Department of Revenue the documents that we actually Heather filed into the court that morning, the Department of Revenue attorney took them, handed them to the person sitting at the table next to him, and never even looked at them.
Yep.
So he never even considered the written arguments that Heather was trying to present.
No, it is very clear that they are trying to destroy me as a human. Yeah, there's no law process to this at all. Yeah. This is them absolutely trying to break me, and because they are buddy with Mary, Ira, and Justin Serlick, that's their mission. Their mission is to destroy me, and except I have the law on my side, not theirs. So they can think they're above the law, but I know without a shadow of a doubt, my argument is 100% solid and factual. There is not a software out there that disagrees with my argument. We have tried in every way to find a loophole to Illinois not having jurisdiction. Literally
asking it, in fact, that's literally, I ran it through one of the softwares today when we got this response, my question was, is there any scenario where Illinois retains jurisdiction? And every option we give it comes back no. Right. Illinois lost jurisdiction. They lost it automatically. There did not have to be a court proceeding.
And why did they lose it automatically? What happened that caused Illinois to lose automatically?
The key issue in Heather's case is both parents and the children in question moved outside of Illinois, and Illinois has a specific statute, so they had to be more than 25 miles outside of Illinois.
But
once that happens, and all meaningful connections are severed, which in Heather's case was she moved to Florida, she changed her driver's license.
That right there.
So she no longer had an Illinois driver's license.
Yep. The moment I transferred my Illinois driver's license to the state of Florida, February 8th, 2022.
Severed any meaningful connection. And so Illinois lost it. And then once the kids had been in Florida for 6 months, Florida became the home state according to the UCCJEA. And then, if you would get into it further, the family court in Illinois, once the juvenile dependency court sent the 3 younger kids to Florida and then reverted the case back to the Illinois family court, the Illinois family court was required under UCCJEA to make a new UCCJEA determination, which they didn't do. Because if they had, they would have said, no, the kids are in Florida. They've been there for more than 6 months as of February of 2022. So they couldn't, they literally, the laws are written that Illinois was required to relinquish jurisdiction.
Yeah.
So
moving on from that, and we'll get to why we're drilling in on this so much in a moment. But moving on, DIN 222 is the new index that was sent from Circuit 7 to District 5 Appellant Court, because my new initial brief is due July 17th, and they have to have the index of record on appeal over to District 5 as of July 7th. Now, this was pushed a whole month because they consolidated my appellant case, where I'm also trying to disqualify this poor excuse for a judge. So that is an appeal as well, because she was allowed to deny her own motion to disqualify herself. That's like going to your boss and saying, hey, you need to be fired. Yeah, no, I don't. And not going to human resources about something. It's ridiculous. So that is, my index is now, looks like 9 pages. So index is literally, it's just a list of every single thing that's in your docket. And hopefully they didn't screw it up, because they screwed it up last time. So we'll see if they intentionally screwed it up again. And then DIN 223 is order on petitioner's motion for written findings and clarification of the hearing.
So this is something that was so interesting, right? So the judge...
This was a denial.
Heather... So after the... I forget which denial it was.
It was I had filed the motion to vacate the April 27, 2022 order. She denied it. It's now on appeal. It's got its own case.
So Heather, when she filed the motion to vacate the order, the judge just came back, adjudicated, denied. No legal reasoning, nothing. So Heather prepared and filed a motion
for
to
written
request
findings, clarification, and rehearing.
Basically giving the judge another chance to get it right.
Yep.
And
as well as she even denied my memorandum of law. Okay, memorandum of laws, and I just learned this in my paralegal class. It's not a thing that you actually act on. It's just filing it into your case saying this is the law on this. So she actually put on this.
She says she looked at it.
The court reviewed the motion in the memorandum of law filed June 9th, 2001, and it's denied.
Well,
all 3 of these are denied.
No, she didn't deny that. She said she looked at it, and she's denying your motion.
And she also denied the first motion to vacate again. So now I have 2 denials on it.
Now, here's the very interesting thing about this. Prior to some of what transpired between yesterday and today, we were already planning on filing a notice of violation on this, because Florida state statutory law requires the judge to issue written findings of fact and conduct a UCCJEA determination, because this is a custody case. That has not been done by this court. But the statute specifically, there are specific statutes that say the judge is required in a custodial case to issue findings of fact and have them written. You can't just deny it like she did. But so that came through. We were prepared to do something else with it, and then some other stuff has transpired.
So DIN 224 is me slapping notice of appeal right on that. And that actually got filed into my most recent. I've got 3 District 5 Appellant Court case numbers now. One is no longer being used. That was the notice of appeal to disqualify her. They consolidated that into my first appeal, which is why my initial brief date got pushed a whole month. And then I have a new 3rd case, and that is the notice motion to vacate the 2022 order here in Florida. And now this notice of appeal of that one is now in that 3rd case, because Florida has had jurisdiction since February 13th, 2022. Mm-hmm. So it is absolutely within their legal right to vacate a void ab initio order from a foreign state. Yeah. I am going to be an expert on UCCJEA by the time this is done. So that's on appeal now too.
We have learned more about the UCCJEA than I feel like most judges in family court seem to understand or follow at this point.
That's why we've been drawing it out in crayon for her. And after today's denial, it's clear she's not reading anything. She basically admitted to not reading anything I'm filing. 225 and 226 are my applications for indigency, waiving the $100 notice of appeal fee because I'm broke. I don't know how they expect me to work when I'm buried in this legal crap. DIN 227, this is a big one.
Okay.
Because I am just getting so sick of this run around in circles when I know without a shadow of a doubt my argument is correct. And they are wrong, I am right. The law is on my side, not theirs. So this is all one motion.
The hearing in front of the child support hearing officer a couple weeks ago. Actually, was it 2 weeks ago today or 3 weeks ago today?
I don't remember. My weeks are blending together because this is my entire life.
I think it was 3 weeks ago today because we had to have it filed within 15 days.
Yeah.
So, after that hearing, there were so many procedural, statutory, constitutional violations.
Just in that 15 minutes alone.
And it's on the record and it's
on YouTube.
That's not just us saying that because that's the argument we want to be able to make. We took the transcript.
And ran it through different programs.
Anybody listening to this, I want you to understand what, some of the tools that we have available. We took the written transcript from that hearing, which we had to pay for. So Heather had to pay for the video recording, and then I paid for a service to do an official transcription.
You can get the digital recordings off of Circuit 7's website, and that's $22 with processing.
We ran the transcript through multiple software platforms. Some of them are generic open source platforms. Some of them are very specific legal research platforms. And we basically just uploaded the transcript and asked the programs to analyze it and identify any issues it thought were significant. And boy, did it identify stuff. Without
right down to constantly being objected to by Attorney Alan Holt of Department of Revenue. He would not let me speak. He kept objection.
The main points,
violating my rights.
The main points, based on just an analysis of the transcript. First off, not just the transcript, but Heather's original motion as well as the hearing notice as well. The case should never have even been referred to the hearing officer because Heather raised jurisdictional arguments. A hearing officer is barred by law from hearing jurisdictional arguments. The case was required to be heard by a judge. Mm-hmm. That's point one. Point two, because it went to the hearing officer and the hearing officer flat out refused to even entertain any of Heather's legal arguments just because they weren't, yes, sir, I paid these thousands of dollars, so don't find against me. Heather's valid legal arguments are that the initial order is void ab initio because the court that issued it did not have jurisdiction to issue it. Also, it was not properly registered for child support here in Florida, which is something else we have found out in doing all of this research.
FSA. right?
Yeah,
UIFSA.
There's one specific statutory requirement that requires a child support order to include a sworn statement of arrearages from the custodian of the foreign state. And that was not included because this was a little unique. It was Heather filing to try to domesticate and register this order, and she was the one being ordered to pay. It doesn't usually happen that way. Normally it's the person who's, wanting to get paid tries to file it to get it enforced. But Heather filed through her attorney. We thought the attorneys do things the right way. Heather filed through her attorney to try to get it opened up in Florida so that things could be modified and she would get time sharing with her kids. And boy, did that attorney drop the ball. And then
Mary Jane Nettles of New Smyrna Beach and Rick Brown of Daytona, Florida, are absolutely going to be sued by me.
They just dropped the ball completely on a number of facts, but
it is going to happen. It's just not going to happen right now because lawsuit is further down the road. But anyways, I have put them on alert that I'm going to be suing them for their negligence in stealing my money.
Heather filed this, and we did it a little bit differently. Talk about drawing things out in crayon. What else did we do with this particular filing?
Yeah, so
that we haven't done before. We did cover sheets,
right?
Color.
So DIN 227 is motion to vacate child support hearing officer Neil Kaufman's recommended order regarding driver's license suspension. Again, guys, this is getting so ridiculous. It is just mind-boggling to me that this is what our taxpayer money is going to. Everyone in the Daytona and Volusia County area should be furious that this is what's happening in our court system because they're paying them to do this. Elected officials get paid by the public. So I did things a little bit differently. I'm stepping up my game a little bit. So each of my exhibits have a cover sheet now, nice and pretty yellow, screaming at them in bright yellow. Exhibit A, notice of hearing before child support hearing officer. There's a lot. So there's a lot of evidence in this. And this motion I filed Saturday, so June 29th. It got processed yesterday morning. And within 2 hours, I was scheduled a Zoom hearing for next Monday, July 7th. So if you're interested in watching this shit show, it is a Zoom hearing, and I will be posting it. I absolutely encourage court watchers to watch this shit show, grab some popcorn, because I'm absolutely going to be telling her that she's violating my rights, and I'm going to be explaining to her why this is void ab initio and not registered properly. There's no point in me arguing about what should be done at this point. She knows what should be done. I'm just going to get it on the record and continuously enforce and defend my constitutional and Floridian constitutional rights. Because that's all I can do at this point, because I'm building a much larger federal case. It is so evident that Florida Circuit 7 is just out to get me because of the Serlicks. So yeah, this is one motion with a ton of exhibits. And then 228 is that notice of Zoom hearing appearance. So please take notice that on July 7th at 10 a.m. Eastern Time, you will be heard for petitioner's motion to vacate child support hearing officer Neil Kaufman's recommended order regarding driver's license suspension, DIN 227, 30 minutes reserved via Zoom appearance only. Now, because I'm starting to be a little bit more proactive with my filings, I filed one of the exhibits was the transcript. So the big paragraph right underneath it is telling me to get a transcript filed over to her within 48 hours before the hearing. So
it's just cookie cutter.
Right. So that would be Friday. However, since I already filed it in, right underneath that in big bold letters, it says the court notes petitioner attached a copy of the required transcript to the motion e-filed June 29th, 2025, 227. So yeah, that's that. So Zoom hearing, July 7th, 2025, 10 a.m. Eastern Time, Zoom meeting ID and password, Judge Sandra C. Upchurch of Daytona, Florida. So I will be posting the Zoom information. So I encourage every court watcher possible to watch this.
I just want to point something out. My guess is the Zoom meeting number, they use the same one for absolutely everything, because the password is the zip code. It is not a unique password.
And then they wonder why their shit gets hacked.
And they wonder why what happened in the prior hearing.
The March 25th, 2025 hearing where it was hacked with porn and then had to be edited out when I requested a copy of that. That was, I thought it was hilarious. General Magistrate Alexander Alvarez and Justin Serlick like,
here's the crazy part.
I don't know where I was
Here's the crazy
now.
part about that. They're using actual Zoom software, which I use for my job. And when you're the meeting host, you literally, here's how easy it is to stop that. You click on Host Tools, and you click End All Audio from, or you hit Mute All.
Alex Alvarez doesn't even know how to use Zoom.
Or you just don't let people come in, and you can block them from unmuting themselves.
Yeah, or you just mute all. Illinois was notorious for doing that to me. Right. I would join the Zoom, and I would be permanently muted, so I couldn't even defend myself. Or they just wouldn't let me in the Zoom at all. So, I mean, we've got Illinois abusing Zoom access post-COVID, and then we've got Florida having no clue how to use Zoom. So, fast forward to today at 3:47 p.m. I get in my docket something a little different, and she damn well should have just shot herself in the foot with this because she gave me an awesome piece of evidence for my 1983, 85, and 86 claim. DIN 229, order denying motion to stay enforcement of driver's license suspension. This cause has come before the court upon petitioner's motion to stay enforcement of driver's license suspension, docket 221. The court, being fully advised in the premise, finds as follows. Petitioner has filed a motion to stay, which for all intents and purposes challenges the proprietary or legal sufficiency of an order that was entered in Illinois in April 2022. Yeah, because it's void ab initio, and it's not even properly registered in the state of Florida to be enforced.
Read the rest of it.
The time to challenge the legality, sufficiency, propriety of that order has long since passed. Furthermore, a stay is only warranted when there is a substantial likelihood of petitioner's success on appeal, which is something the petitioner has not argued to the court, and even if she had, the court does not find that argument to have merit. It is ordered that petitioner's motion is denied with prejudice.
Okay, now
I wish I was joking.
Okay, let's break this down because there's several interesting things about that motion. The first notable difference between that and everything else that has been filed by this judge, that is the first and only thing that has actually had legal findings. Probably now,
because everyone in Circuit 7 knows I have a podcast and I'm calling them out on that.
So here's the thing. Heather hasn't really had a chance to pull that apart yet. She was working on something else when I got home. But what I did is I took the PDF of that, ran it through an OCR to get the text, and then ran the text of that through a couple of our software platforms. And it does not look good for the judge. This is the initial report on all of the things that are wrong legally about it. So, just misapplication of law, failure to conduct UCCJEA jurisdictional analysis, improper standard used for evaluating the state, improper dismissal with prejudice, lack of findings on UIFSA registration validity. I mean, that's the sort of the basic there. But I want to point out... I'm
having trouble trying to figure out if she really is this dumb or if she thinks I'm that dumb.
So
I'm trying to figure it out.
One of the things she said, and this is fascinating to some extent because it is so... Like, when I read this denial order today, I honestly feel any first-year law student wouldn't have been stupid enough to write this thing the way it was
I'm not even a certified paralegal yet, and I know that's wrong.
One of the major things that this judge brought up in there is that claiming supposedly that the time to argue the validity of the order has expired. Okay? Guess what? Basic law, if an order is void, it can be attacked legally at any time. How much case law do we have to freaking show this judge? Okay? These are, look, I had to just get some quick case law on this, and I haven't verified and double-checked everything here, but some of them are cases that we have vetted and have used in motions and that come up quite frequently in child custody hearing cases. I asked one of our platforms to give me all of the Florida case law and rules, all of the Illinois case law and rules, as well as the federal case law and rules that demonstrate the purpose that a void order is, one, void from the start, and two, can be challenged at any time. Here we have Florida Civil Rule of Procedure. This rule allows a court to vacate a judgment if it is void, and courts have consistently held that there is no time limit on motions to vacate. Gonzalez v. Gonzalez, a judgment is void for lack of jurisdiction, must be vacated. Johnson v. Lamontagne reaffirms an order is void, no time limitation exists. Hardman v. Kalinowski, and this is one that comes up commonly in child custody cases. Holding a lack of subject matter jurisdiction renders a judgment void, and a void judgment can be attacked at any time, even collaterally. Stroman v. Stroman, this is another one that comes up commonly in child custody cases. Quoting Hardman, void judgments may always be attacked. Gottsel v. Taylor found homestead alienation orders null and void ab initio, meaning later events could not validate them. People v. Hubbard, where jurisdiction is lacking, any resulting judgment is void and must be attacked either directly or indirectly at any time. Any time. Marriage of Mitchell, I think this one comes up in child custody all the time too. Void judgments may be collaterally attacked only where there is total want of jurisdiction. As in this case, the Illinois court didn't even bother to conduct a jurisdictional analysis. We have the docket. It ain't there. They
didn't bother to do anything properly because they were too busy allowing the Serlick family to kidnap my children and block all access.
Here's the other part about UCCJEA. Even the Florida court here, Circuit 7, has not to this day issued an affirmative UCCJEA jurisdictional analysis. So technically, right now, Florida Circuit 7 doesn't have authority to make any orders because they haven't issued an affirmative determination.
So what do you think my initial brief is going to be all about, guys?
Then we have some additional Illinois statute 735, express statutory provision, relief from a void judgment is not time barred, meaning it can be pursued at any time. Got a couple federal cases here. U.S. Supreme Court, Marshall v. Holmes, federal courts may set aside state judgments obtained without jurisdiction. That's where we might be headed. Numerous state precedents, Georgia, Texas, Virginia, Alabama, all holding that void judgments can be set aside.
Jurisdiction aside, the Constitution states that no state may issue an order against a U.S. citizen that violates their constitutional rights. And if they do, it is automatically void under the Constitution. So we've got constitutional violations in that 3-page Illinois order from April 27, 2022.
Multiple due process violations.
No due process. I wasn't present. I had no attorney present. Therefore, nothing should have been said.
There was not proper notice.
I had no notice that this order was even going to be submitted. I was never sent that order prior to the hearing.
The order isn't even, the motion initiating this is not found anywhere in the docket.
Nope. It just, poof, for the first time showed up April 27, 2022. And then on top of that, I was never properly served that signed order. That also makes it void. Not servicing an order properly also causes them to be void. I was never properly served by Justin's attorney or Illinois Circuit 19 with a certified copy of that signed order. That means they violated service as well. And in Illinois statutes, that also makes it void. It also makes it void under federal statutes. So the Serlicks can argue till the cows come home that this order is sufficient and legal and proper. However,
at some
point, violates my constitutional rights. It violates UCCJEA, and it violates. Countless statutes.
What's gonna end up happening here when we actually present this or when Heather presents it to the appellate court, they are gonna look at it and basically say, was this judge like on drugs or something? She's like the legal argument that we got in this order today is so far. Outside of the practical reality of the law, it's absurd. And I mean, you do not have to be a lawyer to understand this. You can just copy and paste the text into a number of software platforms that can do any sort of analysis on it, and it will kick back so many things wrong with it.
But I mean, let's just pick apart the very last sentence. Petitioner has not argued to the court, which I've been presenting weekly updates for months, showing you, literally explaining it to you on video, as well as giving everyone a link to all the documents so everyone in the world can review these. And I have absolutely, since May 13th, so we're talking almost 3 months ago now, been arguing this, so that is wrong. And then, hang on. And then the very next part, even if she had, which I have, the court does not find that argument to have merit. So she's literally admitting on black and white paper for me to put in my 1983 complaint that even if I did argue it, she would have ignored it and denied anyways. She literally put it in black and white. So this right here, thank you, Upchurch, this right here is my ticket to a 1983 claim and a tort claim. If you guys don't know what tort claims are, I highly recommend looking into it. I have been researching it, and I'm going to have fun with the tort claim. TORT claim. Take a look at it if you feel like you have a government official violating your constitutional rights.
Under the color of law.
Yeah, take a look at that, because I absolutely will be filing a tort claim too. So, yeah, it's been an interesting last week. I, at this point, am building my 1983, 85, and 86 claim. I am, as soon as I'm done here tonight, I've already gotten it written out, my notice of Florida constitutional and U.S. constitutional violations that will be e-filed into my docket tonight, basically putting everyone on alert, officially on the record, that I know that they are violating my rights, and now they know that I know on the record. So when I file my 42 USC 1983, 85, and 86 claims and my tort claims, none of these people should be surprised in the least. I've been screaming it for months, and I made it very clear in my hearing last week. So it's just, this is getting ridiculous.
Here's the last thing I'm going to say
about money being wasted on this crap. Just let me see my kids.
The last thing I'm going to say about what we got today from the judge. This argument that the time to argue the validity of the original order had passed.
That's only the appeal.
Aside from the legal standing that there is actually no legal time limit to argue it, Heather started raising that argument as soon as we learned about it.
Mm-hmm. And the reason we learned about it is because I have a friend of mine that does paralegal work, because she's in the trenches in her own legal battle, and she also specializes in UCCJEA. And she was being very, very specific with asking me where I was at and when. And at the time, I was getting frustrated. I'm like, well, I was here and here and here. And she's like, yeah, but you were in Florida or Illinois? And I was in Florida, but I was in my RV. She's like, that doesn't matter. What matters is what state you were in. And I wasn't understanding why she was asking that. Then, about 10 minutes later, she's like, all right, you got a valid UCCJEA jurisdictional issue, because the moment you changed your driver's license from Illinois to Florida, that meant Florida absolutely had jurisdiction, because you've got Justin that's been down here since 2020. You were down here since December 2021, But then December 8th of 2022, you converted your driver's license, which meant you were then a legal resident of Florida.
And then
February 13th, check that 6-month time mark of Tommy, Bianca, and Charlie being in the state of Florida. So there was 2 times, February 8th for my driver's license, February 13th for the 3 kids. So as of February 13th, Illinois lost all jurisdiction over those 3 children. And that's the law.
And
they're not above the law.
UCCJEA determination is individual per child unless a court affirmatively consolidates cases together. In Heather's case, there was no affirmative consolidation when the juvenile dependency court sent the 3 minors to Florida and then closed their cases and kicked out any custody proceedings back over to the Illinois Family Court. Illinois Family Court does not automatically retain continuing in jurisdiction. They're actually required under UCCJEA to issue a new, conduct a new UCCJEA determination. And had they done that, we wouldn't even be here right now.
Right.
Because they would have stopped everything in their tracks and said, nope, you guys have to be in Florida. Go open a case in Florida.
And that's why 99.9%, if not 100%, confident that they all knew they were doing something illegal. They all knew it.
I mean, when you start
all
digging
of them.
When you start digging
Nurheim
into it,
knew it. Slavin knew it. The attorneys knew it. They wanted that order signed so they could continue to hide my children from me. Because if they transferred to Florida, I would have had a fighting chance at getting 50-50 custody, because Florida is automatic 50-50 custody no matter what. You have to basically be abusing your children to death to lose 50% custody. So they had to have known that if they transferred the case to Florida, like Marnie Slavin ordered me to do on paper February 28th of 2022, that meant that I would have had 50% and Justin would have had 50% based on Florida constitutional laws. The Serlicks don't want that. They want to continue using my children as a weapon to hurt me while continuing to also hurt them. So this is all about abuse and control and manipulation by the Serlick family and all the elected and appointed officials involved. And the Serlick family is literally dragging all of these people down with them. I'm sorry. To federal court I go. There's not much more to be said. I'm done dicking around in Circuit 7. It's very obvious Upchurch wants to be slapped with a federal lawsuit by me, so I'm going to give her what she clearly obviously wants. So tonight I'm filing a notice of violation of Florida constitutional and U.S. constitutional rights into my docket. I will be emailing it off to everyone in Circuit 7 and working on my federal cases. So next we wanted to talk about our 2 new podcasts we just launched literally within the last 48 hours. So why don't you talk about yours first? So
in everything we've been through and sort of a lot of the connections we've been making, it's sort of become clear there's been a group that is you don't hear from very often, and that is supporters of folks battling family court issues. So husbands and girlfriends, husbands, wives, girlfriends, boyfriends, whatever. So in my case, I'm here supporting Heather. I'm not actually, in the family court system. I'm not the one fighting the judge, but I'm here fully supporting Heather.
And it takes a toll on him.
And there's absolutely, as...
Tell everyone what this has been doing to you as a human.
So it impacts everything in your life. I work my regular job full time, and then come home and, to support Heather, I'm helping her with stuff. But then, when she has court hearings, I take time off to make sure she has at least somebody, with her, advocating for her as best I can. I've had to be a witness. I've had to, I've learned more about family court systems than I ever cared to learn. But then, as somebody who loves Heather and, wants to have my own family, everything's on hold right now because of this.
It's been on hold for the last 2 years.
So my new podcast, the first episode is posted. I'm waiting for some clearances to come through on some other stuff before we move ahead. But first episode sort of just has some of my backstory, on how I relate, to the family court system here. But we're going to move on, basically connecting with other folks, just having open, candid conversations with them about their experience supporting their partners going through this. We've already had quite a bit of interest in it. Heather put up a form for people to sign up.
20 people have already signed up.
She'll go through that, but we've had several people that are like, oh my God, this is such a great idea. This has been lacking. We need to be able to, tell the stories about those that are supporting us, because, to some extent we're sort of in the shadows, but we're fully dealing with it ourselves too. So
yeah.
We'll see what happens with the podcast. Like it's almost, honestly, it's to some extent, it's a level of therapy.
Absolutely.
Because you get to actually connect with other folks that have, the same unique understanding of the family court system. And I truly appreciate some of the folks that have already connected with me. Beth, your husband, reached out to me on a day I think you directed him to, but you picked up that me and Heather were definitely struggling that day, and you had your husband reach out to me, and I very much appreciate that. And that's the kind of support that those of us that are supporting our family and friends and spouses need. So we're going to share some stories, and that's what my podcast is. The podcast title is Support Isn't Silent. It's the Support Isn't Silent podcast. It's currently available on most major podcast platforms. I recommend Spotify. That's its primary location. Everything else is an RSS feed off Spotify.
Yep. And then I just launched Disrupt the Corrupt podcast last night. So this one, Justice for the Serlick Children, is to tell my children and I's story, and to get my story out, because I'm still in the trenches of this. It literally feels like it's 5 years of getting nowhere. But Disrupt the Corrupt is specifically for bringing other guests on and letting other people share their stories. So I'll be hosting, very similar to how Marianne Petrie does her Slam the Gavel podcast that I was a guest on in early May. She has been doing this for a while. She spits out episodes like crazy. Obviously, I won't be doing like 5, 6, 7 episodes a week like she does, because I'm still very much in the trenches and I have a novel I have to write by July 17th. But I want to get at least 1 to 2 guests on a week, and that's for victims specifically to tell their story. I am going to be asking everyone to sign up on the sign-in sheet. I have a sign-up sheet that I'll be putting a link to in this YouTube video, as well as on the Facebook link for this. It's already on my Facebook as well. But it is a Google Form sign-up sheet for both Pete and I's podcast. You just select the one that is best for you, or you can also choose both if you want to be on both podcasts. That's perfectly fine. No charge whatsoever. We are all broke because of this court system and attorneys stealing from us. All of us across the nation are trying to figure out ways to survive financially, because this is what the system is doing to us. So I definitely want to get a guest on my show within the next week. So Disrupt the Corrupt and Support Is Not Silent. Both of those podcasts can be found on Spotify. Mine is only on Spotify right now, but we'll get it out to others once I have some guests on the show. But in total, between the 2 podcasts, we've already got, last I checked about 3 or 4 hours ago, 20 people signed up. And just to keep it fair, I'll be going in the order that people signed up. So I'll start with number 1 that signed up and go down the list. But I'm very excited to give others a platform to use their voice, their First Amendment. And it's also, like Pete said, a form of therapy. The more you tell your story, the easier it becomes to handle it. And it's actually a specific type of psychological therapy There's an acronym for it. I can't remember, but it's a form of therapy where you constantly write out your trauma over and over again. And
it's exposure therapy.
Yeah, exposure. That's the word I'm looking for. Exposure therapy. So when you talk about it and talk about it and talk about it, it becomes easier to deal with inside your brain. So, the more you tell your story and get your story out there on all the platforms, so all the podcasts, your story's going to be everywhere. And just like Dave Weigel says, if you get your story out, the narcissists and the people that are the flying monkeys telling the lies about your story, they're going to have less power. Your words are going to be more powerful than the flying monkeys that are lying about who you are and what actually transpired in your situation. So my first episode of Slam the Gavel was very empowering for me. That was really my first time I'd ever spoken to someone outside of my inner circle and put my story out to the masses. So if you have not already been on a podcast, I absolutely encourage you to.
And you do not have to be local. Let me make that clear. We can do this with anybody across the country. We'll just send you a Zoom link.
If you're in Canada, because I know a few of you people up in Canada are dealing with the U.S. because you may have the other partner over the border in the U.S. and you might be in Canada. I know of several people in this circle that are Canadians.
We'll take care of sending you a Zoom link so we can, have you talk to us via Zoom. We'll record it on our end, and we'll get it posted for you so your story can get out once we post. We'll certainly share any links that you guys want us to when we do your podcast. If anybody out there has their own podcast, and you'd like either me or Heather to be a guest, certainly just reach out to us as well. Doing cross podcasting,
advertising each other's podcasts.
We're definitely open to that.
Yep. I am majoring in marketing, I'll help you market.
We want more people to hear stories. As the title of my podcast, Support Isn't Silent. I'm not sitting back in the shadows anymore. When I first got started as a partner, coming into a wild and crazy family court, situation, you do end up sort of sitting back and seeing what's happening, without, thinking you're really going to have to get involved. But the reality is, when you're committed to somebody, you are involved.
Yeah.
And
abuse thrives in silence. And that is how Justin Serlick has been able to abuse me well beyond my divorce to him in June 2013. Because I portrayed our home life as this happy, nuclear family type situation, and it was anything but. Anyone that was truly close to me knew that he was abusing the kids and I, was begging me to get out of that situation, get him out of the house, or move out myself. I was so terrified to do that because of this. This had been hovering over my head since I divorced him in 2013. He and his mother, Mary, told me that if I removed him from the house, they would make sure I never saw my kids again. In 2020, when Mary and Justin told me to kill myself in front of my children, and I almost did just that on the side of I-95, March 22nd of 2020, that was it. I knew that if I didn't break free from this control and abuse, I was going to end up dead. I knew I was going to end up dead. So I had a close friend of mine beg me to get back up to Illinois and seek domestic violence, shelter, and protection. And my children fell prey to the human trafficking that is happening in Illinois, Circuit 19, instead. So, I hope that if you haven't already told your story, you start telling your story because, again, abuse thrives in silence. You need to speak up. And the more of us that speak up about this type of abuse in the family court system and in the CPS system, the harder it's going to be for these entities to bury the story. When a majority of the nation and a majority of the states in our country are screaming from the rooftops that there are problems in family court and in CPS, then the federal courts are going to have to address it at some point. Dustin in Flint, Michigan, was at the FBI building this morning. He went live. I shared his post. He is absolutely whistleblowing Flint, Michigan's child trafficking in the CPS system with FBI agents now. And I've also put in tips to the FBI here in Jacksonville. So it's only a matter of time, guys. We have to use our First Amendment. We have to tell our stories. So I will put the link to the sign up for the podcast in this video and on Facebook for the podcast link. And go ahead and sign up, and I will start reaching out to you. I have created an email for Disrupt the Corrupt. It is disruptthecorruptpodcast@gmail.com. So if you want to reach out to me privately regarding that podcast, absolutely email me. I'll also put the email in.
And same with my podcast, or if you want to reach out to me directly, I've got an email for that. It's host.sispodcast@gmail.com.
Could you make that any more difficult?
I'm telling you, just trying to get a Gmail address that somehow tied in with the podcast was not easy last night. There were so many other, everything I was trying was used. But I got host.sispodcast@gmail.com. So that's where I'm gonna direct people for me.
Yep.
So, but Heather's got the form on hers. When I'm able, I'll share the form as well.
Yep. But otherwise, that's it for now. I've just got to deal with my initial brief that's due July 17th. And I have some other big documents that I'm finishing touches on, and that's going to be filed into a different court. It is not going to be filed in Florida Circuit 7. So now I'm taking it up a notch. I have several writs that are very useful to me, and I am going to be utilizing those writs. And if you don't know what a writ is, it's spelled W-R-I-T. Just search what are the different writs that you can file in court systems, and you'll see what I'm talking about. There's habeas, there's
certiorari,
right,
mandamus.
Yep, there's a whole bunch of them, and several of them absolutely have to do with my situation. They are larger legal documents. They take time to write, so that's the only reason why I haven't already filed them, because it takes time, and I got to research a lot. I got to do a lot of legal research, and most importantly, I also have to put together an appendix, and that takes up quite a bit of time, and I've been doing a lot of research on how to do appendixes as well. And coincidentally, I'm going to leave you guys on this note. I am more than halfway through my certified paralegal course, and coincidentally, I am on chapter 12, which is what?
Legal writing.
Legal writing. So I am coincidentally on the chapter that teaches me how to write those writs and the appendix. It also is covering the initial brief for appellant court in there too, in that chapter. So
it's almost like we timed it.
Right, and I had no clue what the chapters were. Hey,
George wants to be in.
I had no clue what the chapters were. I just divvied 2 chapters a week in, and this week landed on chapter 11, which was legal research, and chapter 12, which is legal writing. So perfect timing for my initial brief. Okay. So Upchurch can take my driver's license away. Whatever, it is what it is. I'll see her in federal court. So thank you so much for tuning in. I really appreciate everyone's continued support. Again, I need to emphasize, if you have not already been on a podcast to tell your story, please, please do. The more victims of family court corruption and CPS corruption that speak up, tell their story, reference their cases, call these people out by name, get their names on records.
And listen here, if you are worried, we certainly understand that sometimes you may not want to give your true identity. When we're recording your podcast, we can certainly not use your real name if that's your wish, but we can still get your story out, and you can then, certainly share the podcast and, tell people, hey, this is me, or hey, just listen to this, and that explains everything.
Right.
So.
And I just got 2 comments from Adrian. And this is what I'm talking about, guys. As we communicate with each other and share stuff, we help each other. So Adrian just said, I was able to hire a paralegal to help get the format correct for $35, my writ of prohibition. Yep. So we got to share each other's resources, advertise the paralegals that are willing to help us, victims of family court corruption. I unfortunately did not do enough reference checks on someone that I hired back in February, and he literally stole money from me. So just also be careful if you're going to hire someone outside of your close network. Just make sure you run some reference checks on, make sure that they're actually doing proper paralegal work, because unfortunately there are some people out there in the Facebook groups
just hoping to make a quick dollar,
right?
And they'll string you along. And
he wasted a lot of my time. So definitely, do your due diligence before you hire someone. I've had a lot of people asking me if I can help them right now.
Just about an hour.
I am not taking on clients right now. Number one, I'm not a certified paralegal yet. I don't want to take any clients on until I pass that NALA exam and become certified, and that won't be until at least August. Number two, as you can see, I'm buried in my own crap right now, and I don't want to mess up someone else's legal documents because I'm so entrenched in my own stuff. So I need to get past this initial brief first, and then once I pass that certified paralegal exam, I can start helping others in this insane circle of corruption that we have all connected with. So with all of that, I'm going to bid everyone adieu for the night. Have a great rest of your week. And I hope to see everyone on Facebook and social media, and you have a great rest of your night. Bye, guys.
Take care.